So I understand all jurors are now present. Anything we need to take up before we bring jurors out?
I was just talking with Mr. Lively and Mr. Waller today, and just some thoughts that we had concerning scheduling. And of course, we will all sides are willing to do whatever the court deems best. I guess we're thinking that right now it's going to be a very short witness, probably 5-10 minutes, and probably an hour or so worth of reading of documents. After which we will have the charge conference, and I know that from experience with Your Honor and Mr. Waller and my own and other cases I've had, that will probably take a couple of hours. We have a lot of mitigating circumstances to go over. We have some proposed instructions and motions as well. And I guess we're thinking at that point, maybe what would be best, rather the proposal of having sort of the jurors wait around and all without a set time, we're wondering if that would be the most convenient time with them. Once we get the instruction conference, it will be a matter of putting together the issues and recommendation sheet. So I guess we both sides want to put that to your attention, and whether the fear of breaking up arguments, I think, is a concern the state has that I kind of share as well. Whether we could get all the arguments done this afternoon with it.
Well, so you're suggesting that the jurors be sent home at approximately 11 o'clock today for the day and be asked to return tomorrow?
That would be a proposal that we would have, and of course we do whatever the court says is best.
I'm not inclined to do that. I think that I'd rather send them for a long lunch and have them come back at 2 o'clock, and that if we need to work over the lunch recess to get the materials ready. Now, if you anticipate 2 hours of close, if you anticipate, one side taking more than an hour and a half to close, then it may be that we only get the state's argument in, or I don't know whether you're going to open and close or what your intention is.
I don't think we have that option.
Oh, so I know you have the last.
We have the last two. I don't think we have.
That may be. I haven't looked closely, but so the state would have the first argument, and the defense would have the final argument.
That's my understanding.
And you would break.
I would like to have the opening too, but I don't think that's.
And that's fine. I haven't gotten that far in my review of the statutes, but in any event, so if that's the case, and if the state intends to take more than an hour and a half to close, it may be that we defer the defense's argument until the morning, but I don't know what the state's plan is.
I think, Your Honor, in working on PowerPoint, my slides are close to 30 slides at this point. So, if you average 2 minutes a slide, that's close to an hour just for me, and then I can't speak for Mr. Lively, but I would assume about the same. I guess we do have a concern about splitting the arguments up for us arguing this afternoon, and then the defense having the sole argument tomorrow morning. That let's let them hear it all at one time at the end, give the instructions, and let them deliberate. The splitting up is a concern to us.
And to kind of echo that, Your Honor, I think that, I don't think there's any conceivable way the jury gets instructed today, if there are 4 arguments. If all 4 arguments were tomorrow and they heard them sort of all morning, and you instructed them, they would, they'd still potentially have a couple hours to deliberate tomorrow afternoon. So it may be that the case, we have a verdict on Friday, whether we do it by splitting up arguments or not splitting up arguments today. And I know that we want to efficiently use our time, but I think that, if it's possible we get the same end result, that we would actually prefer to put it all out at once. But as Mr. Brown said, we're going to do whatever the court tells us
Well,
to do.
as I said earlier this week, what the scenario I really don't like to have in a case of this significance is having the jury begin their deliberations at 3 o'clock on Friday afternoon. I think there is a tendency for jurors to want to finish by 5 o'clock. This jury has not shown that they, won't take the time they need to come up with a verdict. They did that in phase one, but and then they have the weekend, and then we come back Monday. It just seems to me that we are, if we're talking about 2 hours for the state, 2 hours for the defense, my jury instructions, unfortunately, are going to take an hour or more to read. We're not going to get to the jury before 2:30 or 3 o'clock tomorrow, and they're going to have 2 hours to deliberate a penalty phase verdict in a case that we've been trying for 8 weeks. I think that is not the best scenario. And one way of avoiding that is for us to push forward and hold an efficient charge conference and be prepared to do closing arguments today and move forward with this case so that we create enough time for the jury to deliberate. But I'm hearing everybody seems to be very much in favor of not doing it today, and I'm assigned to be right here next week. I'm happy to sit right here next week, but I think that it's
Well, I guess we can kind of take the wait and see approach.
If it only takes them 30 minutes to get through their, review of the documents, and we have a 1 hour charge conference, and
well, at some point I need to decide whether to send them home for the day. I don't want them to sit around for an hour while we do a charge conference and then bring them back in and say, oh, we don't need you anymore today.
Could we just reassess at the end of our evidence and then send them out shortly and then make a decision at that point?
Yeah, that's fine. It's, we have 2 full days left. I want to use them efficiently, and I want to do what's ever in the best interest of justice. I'm concerned about submitting this issue to the jury at 3 o'clock on a Friday afternoon. And so that's the scenario that I'm trying to avoid. All right, let's Welcome back, ladies and gentlemen. Good morning. Further evidence for the defense.
Yes, Your Honor, would we call Bertha Postley?
Yes, ma'am.
And if you would, please place your left hand on the Bible and raise your right. Do you solemnly swear the testimony you give to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Mr. Brown?
Yes. Ms. Posley, I just have a few questions for you that I did not ask you the other day. You talked about the fact that Goldie, your sister's husband, would often beat her. Is that correct?
Yes, sir.
And that sometimes those beatings would leave bruises
Yes.
and black eyes?
Yes, sir.
Your Honor, may I approach?
Yes.
Ma'am, I'm showing you what's been marked as defendants' exhibits S16 and S17 for identification purposes. Do you recognize those two pictures?
Yes, sir, I do.
Do those fairly and accurately reflect what your sister looked like after she had been beaten by Mr. Carroll?
Yes, sir.
Would it help illustrate your testimony?
Yes, it would.
Okay. Your Honor, I would move to admit defendants S16 and S17.
Any objection?
No, Your Honor.
They're admitted.
I'd like to show it to the jury.
Yes. Yes, sir.
If you could step down and tell the judge what the pictures are, and then show it to them.
If you would ask questions to,
Yes. What are these pictures of?
My sister told me that after being in a fight with her, the thing.
Okay, if you could just show them to the jury. Could you return to your seat? Did Lorenzo, Nate Holden, did he ever see her looking like that after the fight?
Yes, he did.
Thank you. I have no further questions.
cross-examination.
No, sir.
Thank you, ma'am. You may step down.
We need the pictures.
Yes, ma'am. Leave them right there. Further evidence for the defense?
Your Honor, at this point, we wish to publish 4 different exhibits that have been previously done. Those would be state defense sentencing exhibit number 1, the report from Mr. Aiken. What are the others? I believe it is, which is excerpts from the Antoinette Holden's rehab documents, 14 school records, and 15 excerpts from the Wake Med hospital records regarding Nate Holden. And we have 14 copies of each exhibit.
All right, so members of the jury, the bailiff's going to distribute 4 exhibits for you to review. Again, take as much time as you wish to review them. As you recall from your prior deliberations, you are given an instruction that if you wish to review these exhibits during your deliberations, we can certainly arrange for that to happen as well, but I'd like you to go ahead and review them to the extent you feel necessary at this time. 14 copies will be distributed. Again, when you are finished with your review, if you'll set them down, look up somehow so that when I look over at all 14 of you, I can tell when you all have finished your review. And please don't write on these exhibits. We'll be collecting them. If you wish to take notes, just do so in your notepads. Okay, ladies and gentlemen, I'm going to ask you to step in the deliberation room for a moment. There are still two important things to do before you begin your deliberation on this second phase. Those are the closing arguments of counsel and then my instructions to you on the law. I will need some time to work with closing counsel on, work with counsel on the instructions that I'll be giving you. And what I'm going to do right now is talk a little bit about scheduling with them. Then I'll bring you back in, give you an idea of the schedule we'll be following, and then we'll go from there. So if you'll just simply step in the deliberation room, leave all your materials there in the chair, and follow all the rules and instructions I've given you, particularly don't talk about the case. All right, outside the presence of the jury, I believe that we should be able to complete a charge conference this morning, and believe that it's appropriate to have the jury come back. I think it's a little bit past 10:30 now. I think we should be able to complete our work in 3 hours, and then be in a position to begin closing arguments around 1:30. So that would be my suggestion, is go ahead and have the jurors come back at 1:30, and we'll simply see how far we get. It may well be that within 3.5 hours we'd be able to complete all closing arguments.
I think that makes sense to at least make that try. I have one concern I have is probably the one who'll be giving the fourth and final argument. I guess I don't want to be in a position to rush my final argument. So I guess if we can just have a way to assess time when it's about ready to get for that argument. I mean, I'm estimating I'm going to take
What
about
I'm
half an hour.
inclined to do is ask the jurors right now whether, if we did run a little bit past 5 o'clock, whether they would be able to make arrangements to allow that to happen, just so that we don't feel rushed at the end of the process. I would expect that the jury might be willing to do that, but so I'll make that inquiry now. But so that would be my suggestion. Go ahead and release them till 1:30, and then we'll just use our best efforts to complete what we need to do before then, and be in a position to move forward. Yeah, let's bring jurors back in, please. Electronic copies of jury instructions. Any of you want printed copies of them?
Yes, sir.
All right. 4 of them, one for each counsel. Yes.
The difference in what were sent last night. These are the ones that were sent 5 minutes ago.
Right.
Sure.
So,
Yes.
I think we would like printed copies. We're each working on our own presentations.
and 1 for the court reporter, so 5 total. Gentlemen, looks like that the schedule that may work is to go ahead and release you until 1:30 this afternoon, and then have you come back, and at that time we should be in a position to move forward with closing arguments in this case. The closing arguments may take the remainder of the afternoon, and one concern we have is we don't want to get to right at 5 o'clock, have the final arguments being made, and then have to interrupt and have those carry over until the next morning. We think we can fit it in before 5 o'clock, but the one question I'd ask for you, if we do run over 5 o'clock by 10 minutes or 15 minutes, would that create any particular problem for anybody today? All right. So what my expectation would be as far as the schedule, assuming that no glitches come up in the next 3 hours while we're working on the jury instructions, is that we'll be ready to go with closing arguments at 1:30. We'll spend the rest of the afternoon doing that. Tomorrow morning, I will be instructing you on the law, and then after that, you'd be in a position to deliberate this case. So trying to give you a good bit of the day tomorrow for your deliberations. And of course, as you know, you can carry over into Monday or as long as you need to go on this matter. So that's the schedule that I think will work for us today. So if you'll just simply take a recess and come back to the deliberation room at 1:30. And please follow all the rules and instructions. Don't talk about this case among yourselves or with anyone else. Don't form or express opinions about the outcome. No media or independent investigation of these matters. And no conversations with parties, witnesses, or lawyers. Leave all your materials there. We'll be collecting the exhibits that were handed to you, and leave the notebooks in the chair as well. We'll see you back at 1:30.
This is the state staff.